Let me thank the members who are present. It is unfortunate that we had to wait for more than an hour since the scheduled start of the meeting for a quorum. I am particularly displeased and concerned that the business for today is a review of the pre-charge bail regime. And this is a matter that has been regarded as most controversial, not only by the parliamentary opposition, but also by members of the public who have taken the time to make presentations. The committee took the decision to review the other provisions of the bill and then return to Clause 5, which sets out the pre-charge bail regime. And at every stage, we indicated and agreed that we would come back to this matter, including at the last meeting of the committee on Tuesday of this week. The parliamentary opposition members had asked in particular for guidance from the Attorney General's chambers on the constitutional issues raised by the many presenters, including questions of their own. We thank the chambers for preparing a very thorough document of 21 pages presented by Mr. Foreman, Jeffrey Foreman, on behalf of the Attorney General. And I don't know if, having benefited from that presentation, the concerns about the constitutionality of the regime have gone away. I don't know, because I cannot speak for members of the parliamentary opposition. What I can say is that we have discharged our duties to answer the questions. But I suspected that there may be other issues of concerns based on what has been said in the past about the regime. But I do not have the benefit of members of the parliamentary opposition today. Senator Scott Motley did tender an apology, and I think along the way apologies came in from Member Paulwell, who was advised that he's in a funeral in St. Catherine, and Member Jackson, who indicated that he is caught up in his constituency and would try to make it in the afternoon. I have not received any communication from Member Bunting. The work will go on, as much as I would have preferred to have the benefit of the members of the opposition who express concerns about the regime, to indicate what remaining concerns they have after the clarity was presented by the Attorney General's chambers. I am generally concerned about the approach we take to lawmaking. I am generally concerned. Parliament is tasked with making laws for peace, order, and good government. And we are challenged on all fronts in the society. And in this case, where the government has taken the decision to update the law and to address some of the pressing challenges, respecting the rights that are guaranteed, but also making it clear that the rights are not absolutely guaranteed. But where derogation is necessary, there is a standard of derogation. And part of the work of passing laws and putting them at the early stages for review through a committee like this is to not just interrogate the law, but also to educate the public along the way, those who choose to join the discussions and who tune in. That's why the proceedings of Parliament, whether meetings of the whole House or committees of the Parliament, are televised live so that members of the public can have the opportunity to tune in where they so desire. I feel that it is really unfortunate that we had to wait more than an hour for a quorum, and having formed the quorum, the opposition side of the Parliament is not represented through its committee members. All right. So the apologies that I have received for absence are from Senator Scott Motley, Member Minister Horace Chang, Member Paulwell, and in my own efforts to reach out to Member Jackson, he, at a minimum, has indicated that he will be late. The paucity of resources has impacted the work of the committee. I've been advised by the committee clerk that the minutes are not available. Minutes of Tuesday's meetings, the meetings before Tuesday, those minutes were also not available, and that is because the clerk who's assigned to this committee is also assigned to numerous other committees, and the committees have been meeting back to back, sometimes for the full day, leaving little or no time for the minutes to be prepared. I do not hold it against the committee clerk. I know she is diligent, and the quality of the minutes she produces is usually high and accurate. There will always be things to correct, and that's why standardly, before minutes are confirmed, they are corrected, but that is no indication on the quality of the work generally, from my experience in this meeting. It's just the fact that the minutes are unavailable today is just another indication of how sparsely resourced the Parliament is. I know my government has taken note of it, and I look forward to the remedial steps being taken soonest in the new legislative year, because we cannot continue in this way. There's a lot of work ahead of us, and this high democratic institution of our nation needs to be better resourced. I am consoled that consideration has been given. I just look forward to the implementation of the decisions taken so that we can enjoy the benefits. When we last met, we had completed review of all provisions of the bill except for Clause 5 and the schedule. Today it is the intention to proceed to complete the review of the bill, leaving time for the outstanding minutes to be prepared and for the report to be prepared so that we can present the report to Parliament and then take the bill through the other stages to conclusion of passing it in the House, sending it to the Senate, and passing it. All right. I invite the Madam Director of Legal Reform to take us through. I think we would do the schedule, or do you suggest we go to Clause 5? We could go directly to Clause 5 and then we come back. Right. Comments on Clause 5 begin on page 8 of the bigger of the two matrices. Page 8, at the bottom of page 8. So just to remind, the Clause 5 in this bill, there are 3 stages at which bail may be granted. The first stage is where someone has been detained on reasonable suspicion of having committed an offense. And for the purposes of this law, there are specified offenses that are listed, which are punishable with imprisonment. But having regard to the harsh realities of the Jamaican society, more time is needed to prefer charges. And in an effort to ensure that no one languishes in custody unless sufficient cause is shown, the government has taken the decision to provide a new regime for dealing with people who are arrested on reasonable suspicion of having committed an offense, but against whom charges are not immediately brought. Has to be understood that where offenses, serious offenses, are alleged, the interest of justice requires that they are properly investigated and that those who commit the offenses are held to account. And they are entitled to due process and every right that is guaranteed in the process while they are in line to be tried and sentenced. If found guilty, they have to be treated in a particular way. So let us go to page 3 of the bill, Clause 5.1. Alongside, of course, the submissions we have received, which are set out at page 8 of the matrix. Madam Director, Legal Reform, please proceed. We're going to be examining the comments against the provision.
I'm not clear. What is it? Is it the matrix? Is it the bill? I'm a little confused. What is it that you're going to?
What is your suggestion as to the order of proceedings? We're
not
proceeding to review the comments that
all
have
of
been
them
made.
or the ones, because there were decisions for some.
Right,
and
the
some were
remaining
deferred.
ones. The remaining ones, yes.
That is the. Boy. Sorry.
So primarily, what we are contending, what we are grappling with the major contention that the Constitution of Jamaica does not allow for pre-charge bail. I think that issue has been clarified, but it doesn't mean that all of the concerns raised have gone away. But that was a primary contention by many who presented. If they had the benefit of the written analysis provided by the chambers as well as the presentation, I would like to know what are the remaining concerns. But let us proceed.
Chair, is it possible for me to get a copy of that written analysis? I had indicated that I would be unable to attend the previous sitting, so I didn't get a copy.
Member, could you just check your email?
Okay.
Right. The document was emailed some time ago.
I don't have a lot. So I have to go over the whole thing. Page 7. Yeah.
All right, you may proceed.
Having looked at it, I think perhaps we need to just go over them. In the case of the Jamaica Bar Association, in relation to Section 5, this new concept of pre-charge bail should be restricted in clear terms to cases in which there are reasonable grounds that the suspect has committed an offense from Part 1 and Part 2 of the schedule, and there are reasonable grounds for believing that the suspect will abscond, commit an offense while on bail, interfere with witnesses, or interfere with ongoing investigations. While Jambar has supported Parliament's intention to introduce this new concept, it is our position that its wide operation cannot stand up to constitutional scrutiny in a free and democratic society. It is without a doubt that this concept impacts upon the constitutional rights of citizens, including their right to liberty, privacy, and freedom of movement.
Madam Chair, I'm sorry, but I'm at the back of the class today. Can you remind me where SG was reading from? Oh, it's not SG.
It's not the Solicitor General, it's the Director of Legal Reform.
I took off my glasses and glanced
Right.
and I realized.
Ms. Nadine Wilkins.
Ms. Wilkins.
Page 7 of the matrix.
It's all right if we look alike. We do. We're both very attractive.
Even if you say so yourself, Ms. Wilkins.
So it's Jamaica Bar Association, page 7, the recommendation. Thank you.
Correct.
Thanks much.
All right, so the bar is saying that the concept of pre-charge bail should be restricted in clear terms to cases where there are reasonable grounds. That this, maybe a starting point could be the contention that the word defendant should not be used as an umbrella term for all persons who are detained or arrested on reasonable suspicion of having committed an offense. The view that was expressed is that traditionally the term was used for persons accused, formally accused. The CPC has explained that, well, let me throw it over to you, Madam CPC. You would have heard, I think you have already presented a view. I don't know if you feel fortified in the view in light of the analysis provided by the chambers addressing some of the concerns.
Yes, somewhat, Madam Chair. I mean, I have always said in explaining that it was considered a suitable umbrella term because there's this link having regard to the fact that the person is involved in criminal proceedings at that stage. So it is one continuous set of proceedings from the moment that the person has been detained on the suspicion that the person has committed an offense, straight through to the point where the person is actually charged, straight through to trial, straight through conviction, if that is what occurs. So I'm not seeing where there is this break in the proceedings that would suggest that that person shouldn't be termed a defendant, especially when you consider that there is a presumption of innocence that attaches to any person before they are convicted.
Before I invite comments from Mr. Foreman of the Chambers, let us be clear that there is, in fact, a term in the criminal justice system for a person at each stage. So the person who is reasonably suspected of having committed an offense is generally regarded as a suspect. And that term is a term that is well known to the criminal justice system. After the person is formally charged, the term accused is used. And after someone is convicted, that person is a convict. So there are terms that could be used for each stage. It was felt that using the term defendant would be least prejudicial and would allow for drafting ease. Mr. Foreman, may I invite any comment from you having regard to the issues raised and also your own analysis? Because the thinking of some of the presenters was that since no charge has been preferred against the defendant in the pre-charge stage, that person is supposed to be treated in a different way. Your analysis shows that for the purpose of arrest or detention, it is the same threshold at that early stage that has to be crossed. It's the same threshold of reasonable suspicion that the person has committed an offense. It's just that the charging has taken them further down in the queue. May I invite any comment from you?
Sorry, Chair, my only comment is to say that my understanding of the various submissions was that they would feel more comfortable, as it were, with different phraseology. I don't see, for my part, a legal implication of using one term over another. Especially having regard to the fact that the word defendant is itself defined in the legislation, and that when it's used in clause 5 versus when it's used in clause the other clauses, the definition would clarify the specific context. So from that strictly legal perspective, I'm not bothered too much. So it's a question of whether the committee...
Is it that you're not bothered too much, or there is no legal issue that arises? I think clarity in the response will also be helpful for the record.
That's right. It's more of not a legal issue on my part. So it's a question of whether the committee accepts the views of the stakeholders, the submissions, that it's preferable to use a different description for the person who is at this stage of the proceedings, having regard to the fact that what the society, they say, is accustomed to is these sorts of measures only being applied to somebody who has been charged. So that's I would say is what you ought to bear in mind. It's more of a response to the stakeholders and those sorts of considerations that are purely that one that's really tied to the legal consequence.
Thank you, Mr. Foreman. So, if the committee accepts that there is no legal or constitutional issue with the use of the term, the real matter for consideration is how we balance the perspective of the draftster against the concerns raised. If it is simply a matter of comfort, I think it may be useful for us to bear in mind that every time we push the frontiers and we embark on, we go into new territory, our comfort level will be impacted because we are actually stepping out of the norm as we knew it into a new area, and it will take time for adjustment. I know Member Campbell Rodriguez had expressed some views, I don't know, with the passage of time and having had the benefit of the clarity from the chambers, whether you are softened on that initial concern that is raised. And just to bear in mind that if we don't use it that way, then we will be referring to the person who is convicted as a convict, which some feel is even a little harsher than referring to the person suspected, reasonably suspected of having committed an offense as a defendant who is in fact engaged in criminal proceedings, though not yet at this stage, not further in the queue.
Madam Chair, I have softened to the point of saying we just need to ensure. I know we often say we need to communicate with people and then we don't. In many of these committees, we say we need to ensure that people understand. I think for this specific thing, more than anything else, we need to ensure that persons understand. Because I think what was said a few minutes ago by Mr. Foreman is quite telling. His last comment, yes, Mr. Foreman, you're looking at me at the top of your glasses, but yes, what you said, it's not a legal matter, but it's, and I'm paraphrasing, it's how people feel about the use of the word, which was my concern in the beginning. It wasn't about the legality of it, it's how people feel. But I believe if we educate around it, we can get by it. So to that extent, yes, I've softened.
Thank you, Member Campbell Rodriguez. I think, you know, we often speak about the need to educate. And it is my hope that as we reorganize government, as Prime Minister Holness is doing, that we will take this role seriously. And it is my hope that all members of this committee will help in that work as you go back, those who interact with members of the public at all levels, especially constituents, because after all, it's the constituents who send us here. This is not to say that the appointed Senate does not interact with constituents. You must just do so in a different way. All right, so the committee will take a decision that we will retain the use of the word defendant, having balanced the views raised and having heard the explanation and been And also, if you, having accepted the guidance that there is no legal issue per se around the use of the term. Right?
Okay.
Very well.
I think the issue I read from the Bar Association, I think the bill sufficiently restricts it to reasonable grounds, and the basis on which it is granted already encompasses the concerns about absconding, committing an offense on bail. I think the bill satisfactorily addresses what is there. So I don't think there is any need to do an amendment in relation to those comments.
Again, there is a constitutional threshold that you have to cross to ensure that the deprivation of liberty is not arbitrary. Where the deprivation is being done in relation to offenses, at the earliest, there has to be reasonable suspicion that the person to be deprived of his or her liberty has committed an offense. Many other things flow from that. So, the provision here is that it is on reasonable grounds. You know, even worded a little differently, that some may say has elevated the threshold. And the provision also specifies the type of serious offenses within the jurisdiction, and those are offenses punishable with imprisonment. So at the end of the day, if you're convicted, you would be losing your liberty. As the Constitution say, you can properly lose your liberty after conviction. Yes?
Okay,
so that next issue, so the first issue is the use of the term defendant. The second issue is the threshold.
For Camille Golding, Section 5 elucidates the right of the defendant to bail from the perspective of his constitutional rights. Hence, it is adequately explained. However, Section 5.3 poses constitutional issues as holding an accused person in custody for 120 hours to await an identification parade. Though it may be necessary to, inter alia, cause witnesses to be found to take part in the identification parade, it may raise some issues from a human rights perspective. It is thus suggested that the 48-hour time period specified in Section 5.1 be retained. Hold on, it's 5.1 of the Act.
So when I hear a concern raised from a human rights perspective, I'll just share what comes to mind from the lens through which I filter. One, is it a right that is guaranteed by law? Rights can be provided for at different levels. If it is a right that is guaranteed at the highest level of law, that is a constitutional right, then you consider whether that right is absolutely guaranteed or otherwise. In respect of, there is hardly any right that is absolutely guaranteed in our Constitution. There is a limitation. So you look to see what is a permissible limitation on the rights, and when is the right properly engaged, and what is the standard of derogation. And on all those matters, we have guidance, the analysis that you have to go through to ensure that the approach taken is constitutional and lawful.
Thank you.
In respect of prescribing a maximum time for doing something, perhaps it may be helpful to look comparatively at when a maximum sentence is prescribed. It doesn't mean that in every case you hand down the maximum sentence, but it just means that you can go up to that limit. there are important administrative steps to be taken in the holding of an identification parade. And I believe part of the education and re-education of the security forces is to help them to understand that where time is set, it does not mean that in every case you use the maximum time. If we're committing to serving the public more efficiently and effectively, then actions must be taken as quickly as possible without compromising the steps that properly must be taken and for which time is required.
Chair, perhaps we should look at the Constabulary Forces comments, yes, which are on that very issue. In section 5.3, we submit that an amendment is necessary to provide for the matter to be referred to a judge in chambers within 120 hours of the person's arrest or station arrest. I would think he meant detention, for such orders to be made in the defendant's absence. And they're referring to the section 22 of the current act, which makes provision for that, for it to be considered in the absence of the individual. We recommend the incorporation of this part of section 22 of the current act into section 5.3 of the bill. This would assist in preserving the anonymity of the suspect in circumstances where the identification parade could not be held within the timeline stipulated and will remove the possible concerns of defense counsel. Further, this amendment may result in the need for an amendment to section 63 capital A subsection 3 and 4 of the Judicature Parish Courts Act, which can be achieved through sections 24 of the bill. The rationale. Section 5.1a of the bill allows for the question of bail to be considered within 48 hours where a defendant has been arrested or detained but has not yet been charged. Section 5.3 of the bill goes on to require a defendant to be brought before a judge within 120 hours where an identification parade is required. In the event, however, that an identification parade is not held within 120 hours, the requirement to be brought before a judge still remains, and exposing the identity of the defendant prior to an identification parade can have serious implications on the integrity of the identification parade. This is because any witness could have had the opportunity to have cited the defendant prior to the identification exercise. So, I think the main thing is provision to be made for the decision to be taken in the absence of the suspect.
Can you just explain what you understand the submission to be asking for?
Well, okay, so the issue is being raised by Community Golding, but the solution is being proposed by the GCF. They're both seeing that there could actually be a problem here. So
concern is that where an identification parade is to be held, the suspect should not be exposed because it may be prejudicial. The prejudicial effect of such an exposure may outweigh anything, because you don't want anyone surreptitiously pointing out the person. Or
correct.
Right. Those are real concerns in the criminal justice system. So they're asking to ensure that the law makes adequate provision or carries over provision aimed at ensuring that a suspect, a defendant not yet charged, and who is awaiting ID parade is not exposed.
Yes. Section 22 now, in its second paragraph, says that where an identification parade is required in relation to, in this case, a person who is arrested or detained, the person shall not be brought before a resident magistrate or a justice of the peace, but the matter shall be referred to a resident magistrate or a justice of the peace, who shall make any such order in the absence of that person. So that is what they want restored. They want to
Are they saying it has been taken out? It's in the Bail Act. It's in
the current Bail Act, and we don't have it in the Bail.
All right, let me hear a response from the CPC.
Well, I was just looking back and wondering if it was omitted because of what was provided for in subsection 3, which gives a longer time before the person is to be brought before a judge. I'm thinking, was it intended that the identification parade would take place during that time before the person is brought? Because it has been 120 hours is given instead of the time specified in subsection 1.
I think the issue CPC is the be brought before the judge. That's not now necessary.
Yes, but I'm saying that it's still providing for the person to be brought before the judge instead of the order being made in the absence, because a longer time is being given here, presumably to allow the ID parade to take place before the person is brought before the judge. That was my understanding of why it was done this way.
My one concern is whether a defendant who is to be placed before an identification, where a defendant who is to be placed before an identification parade is not so placed within the specified time, how is that person treated in the law? That is the question I would just ask you to answer for me. Yes.
The law at present does not require that person to be brought before the judge in court. It makes provision for the question of bail to be considered.
So from a practical standpoint, you can understand why there would be no provision for the person to be brought before the court, because you're not exposing the person. But Madam CPC, how is that dealt with?
Well, I'm saying just if the policy is still that the 120 hours would apply to enable the ID parade, then 3 could perhaps be tweaked to provide that the ID parade, for the purposes of holding the ID parade, instead of the time specified in subsection 1, the time would be 120 hours. That would make it a bit clearer that the purpose is for the ID parade to actually have taken place before the person is brought before.
I think that may be an improvement on it, but I think the question still remains if at the end of the day they are unable, notwithstanding the time specified in the law for the holding of an identification parade, especially if it may be a case with multiple accused, multiple defendants, how would it be provided for? Because you still wouldn't want to expose any of them to cause a prejudice.
Well, I'm not saying that this was a better solution than what exists now. Maybe reverting to the current scenario where the person is not required to be brought might be the better answer.
You would still allow an extended time frame within which to hold the parade, given just the complexity of matters. You want to weigh in on this, Mr. Foreman?
Yes, my concern, though, is that there's still the requirement to bring the person before a judicial officer as soon as possible, so that if it's reasonable in a particular circumstance to give the officials 120 hours to have the parade done, at that point in time, if the matter is so complex that more time is needed, the judge should be the one to authorize the continued detention for the purpose of giving an additional day or 2 or whatever the case may be for that to be done. So it should be a judicial decision at that point in time.
Well, 2 things. I agree it should be, but the other thing is that there really should be the requirement to bring the person in person maybe should not be there, because the harm can be done in the transition of the person between the lockup station and the court, holding the person in the precincts of the court while the matter is to be heard. So let us strike a compromise, Madam CPC, that where more time is required, that decision is to be taken by the judge, and that in such a case, you wouldn't have to bring the person, but the order can be made in the absence. Because you can have, in a worst case scenario, a complex matter, everything is in place, and at the very last minute something happens and the ID parade is not held. But you still need to have an ID parade in order to proceed to charge the person.
Try this one.
Where it is contemplated that there's going to be a parade, identification parade, that the defendant be kept out of court completely. If that position, which is current, is maintained, what harm would it do?
I'm not seeing one immediately, but I don't know if the technical team. Let's just look back at the recommendation. So the recommendation speaks to 5.3, a submission that 5.3, an amendment is necessary to 5.3 to provide for the matter to be referred to a judge in chamber within 120 hours of the person's arrest. It couldn't be arrest or station, arrest or detention, for such order to be made. In the defendant's absence. And then they point out that currently, Section 22 provides that, provided that where an identification parade is required in relation to that person, the person shall not be brought before a judge of the parish court or justice of the peace, but the matter shall be referred to a judge of the parish court or justice of the peace, who shall make any such order in the absence of that person. We recommend the incorporation of this part of Section 22 of the Act into Clause 5.3 of the bill. This would assist in preserving anonymity of the suspect in circumstances where the identification parade could not be held within the timeline stipulated, and will remove the possible concerns of defense counsel. Further, this amendment may result in the need for an amendment to Section 63A 3 and 4 of the Judicature Parish Court Act, which can be achieved through Section 24 of the bill. And the rationale, they say, is that Clause 5.1a of the bill allows for the question of bail to be considered within 48 hours where a defendant has been arrested or detained but has not yet been charged. Clause 5.3 of the bill goes on to require a defendant to be brought before a judge within 120 hours where an identification parade is required. In the event, however, that an identification parade is not held within 120 hours, the requirement to be brought before a judge still remains, and exposing the identity of the defendant prior to an identification parade can have serious implications on the integrity of the identification parade. This is because any witness could have the opportunity to have sight of the defendant prior to the parade. I think the concern is a proper concern raised in respect of the gap. So what part of the review is to increase the time within which the parade can be held to allow for the complex cases. That's an outer limit. But under no circumstance would we want to have an improper exposure of someone who's to be placed on an identification parade. And to the extent that it requires that the defendant be taken before the court without more, then we may need to adjust the provision. Madam CPC?
So I had done what you had referred to before, which was a combination of the two,
Yes.
which keeps subsection 3, but just adds a second tier. So we could divide it. Where an identification parade is required in relation to a defendant, the defendant shall, instead of the time specified in subsection 1, be brought before the judge within 120 hours after the arrest or detention, or B, in any case where the identification, and B, in any case where the identification parade is not held within the time specified in paragraph A, the matter shall be referred to the judge, who shall determine the question of bail in the absence of the defendant. I don't know if you still want the judge to have the power to extend
Just
the
go
time.
again for me, because I'm not sure. I see the Director, Legal Reform, shaking her head. What are you shaking at, Ms. Wilkins?
The amendments proposed isn't getting to the gravamen of the issue. The constabulary force is saying we do not wish for the suspect to be brought before the judge because of the dangers that they have set out. They want what we presently have to continue. What we have done that is different is that we have stipulated a time. The law at the moment does not tell them they must do it within a specific number of hours. It just says it must be brought before the judge and it must be determined in their absence. What we have done is to say it must be done within 120 hours. That is new. But they're asking for the ability for it to be done in the absence of the suspect to continue. So if you leave the first limb that you have, we would not have satisfied that concern.
Yeah, but wouldn't the second limb have satisfied it
But
if
then,
the ID parade, in any case where the ID parade has not been held? You
yes,
would
but
then refer to this position?
No, it's not where it has not been held. They're saying that they don't have a difficulty with 120 hours, you know. Their difficulty is the requirement that the suspect be brought before the judge. That is the concern of the JCF.
Madam Chair, let us inquire as to the use of the word judge as opposed to magistrate. Are we contemplating that it's one and the same?
Counsel, you do know that the term judge is defined in the law and that we don't use magistrate now in respect of a judge of the parish court. And for lay magistrates who are justices, they are really referred to as justices.
Very
but
well.
yes, so that I know you haven't been practicing for a little while in the court. Yes.
At different points, I've heard
Right.
before the magistrate and then I
Right.
heard judge.
So judge is defined in this bill to mean a judge of the parish court, a judge of the Supreme Court, and a judge of the civil court, of the Court of Appeal. Yes. I think the concern is where an identification parade is required in relation to a defendant, the defendant shall, instead of the time specified in subsection 1, so here is the challenge. We were expanding the time to enable an identification parade to be held. I think as worded, it's not actually capturing. It will be interpreted in a different way. So yes, we are extending the time frame within which such a defendant who is to go before an ID parade is to be taken before the court. But we are also saying that in the event that the ID parade is not held, we don't want the defendant to be taken in person, risking an exposure. We want the court to make the order how to deal with that defendant in the absence of the defendant being exposed. So three things, is that more time has to be given where a defendant is to face an ID parade. And that is where the 120 hours come in, as opposed to the other 48 hours if they remain in custody. But you
Chair, I just want to point out that there is at present no limit on time. There is no stipulation at the time in Section 22. It
Yes.
just requires that it just provides for it to be done in the absence of the.
Maybe that's a better approach.
I'm thinking
That if instead of the time that is specified, if the parade is not held, but what if the parade is held and the person is denied bail still?
it would have been the court. That would be. You mean? Oh, you mean by the
Right.
police or the JP?
Or if the parade is held,
Yeah.
and for that, so you may have a suspect that is brought in for multiple offenses, and you're holding a parade one by one because it's a different set of witnesses, right? So they are not identified in parade number one, but you still can't let them out because there's another parade that is to come. I think we would still need a provision for some order to be made in respect of that person. And the order really would be along the line that the person be further detained to face the ID parade in respect of the other matters. Yes.
As it stands currently, that is precisely the approach in our courts. 'Cause as it stands, if the police need more time to conduct an ID parade, especially on a habeas corpus application, they usually attend on the court and indicate to the judge that they need time, and the judge usually inquires into the matter and exercises a discretion and determines whether or not to grant the police time to do their parade. This happens primarily on a habeas corpus application, as it is in the courts. Now, usually if there is, we have had experiences where, officers have had difficulties finding witnesses or having witnesses cooperate to come and do the parades, and myriads of supervening events could prevent the expeditious conduct of a parade. And it is the judge currently that really manages that situation. Where an inordinate time has passed and there is no proper explanation, and it doesn't seem that this parade is getting off the ground, judges usually make a decision as to whether the person is to be charged or released. Because if it is that the identification parade is critical and is absolutely necessary, let's say identification is a primary issue in the matter, and the person is not identified, then that's the end of the matter. If the person is identified, then charges flow. So it becomes now, the whole question of bail now arises when the person goes before the court, having been arraigned before the court, and a bail application is made. So my concern is that in relation to Section 3, as it stands now, no person who is scheduled for an ID parade is brought before the court. It doesn't happen. If that happens, then
This would do a harm to that.
this would,
Yes.
what this would be doing is,
Exposing,
flying in the
causing an
face, the whole
exposure.
question of
Right.
exposure. So
Right.
as it stands now,
it's really you want to deal with the person. You want to, the purpose of bringing
Yes.
the person before the court is to ensure that no one is held in custody beyond a certain time frame without being brought before the court. But a defendant who's to face an ID parade is in a little different category, and any exposure of that person can compromise. The interest of justice may not be served.
So as it stands now, they are not brought before the court.
Right.
What the judge does is to manage the situation, determines how much time the police needs, ascertain from the investigators how much time is needed to carry out that parade, and the judges use their discretion and manages it. If it becomes inordinate, then they make orders. So
it's not necessarily that this is wrong. It's just that it
Yes.
didn't contemplate another
Yes.
aspect of it. Because the point is that it's not everyone who is held in custody to face an ID parade, that the ID parade will not be held. right? So you have the situation where the ID parade is indeed held within the time frame and no bail is granted at the station. And then the requirement is for that defendant to be brought before the court for the court to consider the issue of bail, because the regime is that there is, except for those matters where only the judge has the power to grant bail, bail has to be considered first and foremost at the point of arrest or detention within a 48-hour period. And if you grant the bail, so be it. If the bail is denied, then you have the other 48 hours within which to take the defendant before the court. So it expands the time to take the defendant before the court where a parade is to be held.
Yes,
right? So this provision at 5.3 is actually contemplating where the parade is indeed held and the person is denied bail, and then they have the next opportunity is before the court. What it does not include is that there is a high possibility that in some cases a parade may not be held, but you still have a requirement to get an order of the court, but the interest of justice would not be served by exposing the person and taking him in person before the court. So that's a gap that we just need to address.
My view is that, milady, that could be, we could find a way to put that discretion in the judge on an ex parte basis, for want of a better term.
Well, the real concern is that if the provision stays as it is without more, then you will have harm being done to the defendant who is to face the parade, but no parade was held, if you have to physically bring the person before the court. So I think that is what we'll have to make the adjustment to accommodate. And the suggestion from the constabulary force is that we could retain some of what is in the current law. But I was saying that it's not just retaining that, but bear in mind, you may also have a situation where the defendant has faced the parade, but bail is denied. But under this, so you remember in the pre-charge regime, the person is not yet charged. So they may face the parade and they may be identified, which takes the process a step closer to the person being charged. But you may still have other things. It is my hope and expectation that once you get to, if you take the person in, he or she is not charged, you would have had, if the issue is one of identification alone, the case file would be ready, except for the determination that this is the person who's actually the one said to have committed the offense. And right after the holding of a parade and the identifying of the person, you would move to charge. But the reality is that a single person may be implicated in multiple cases of wrongdoing. And you would still have to sequence the step in placing them before an ID parade, because holding one parade wouldn't be the same for all the matters for which the person is being investigated, because that's the reality of the system. Any comment from the technical team? Let me just give the drafter a little time to propose how we could address the concerns.
All right. 3, where A, more time than the time specified in subsection 1 is required for an identification parade to be held in relation to a defendant, the defendant shall, instead of the time specified in subsection 1, be brought before the judge within 120 hours after the arrest or detention. Or B, an identification parade is required to be held in relation to a defendant but has not been held within the time specified in paragraph A, the matter shall be referred to the judge, who shall determine the question of bail in the absence of the defendant.
Back to A for me, Madam CPC, I'm not so sure. So just remember that we give more time for the holding of the parade. But if the parade is not held, we do not want the person to face the court in person, risking exposure. What the police would just be seeking is more time to hold the parade in.
And not to be held in the absence of the defendant?
Well, going to the court, the court would deal with the person in their physical absence, because the harm identified is a risk of exposure if you take them in person.
That's what I just read in B.
Oh, just read back A for me.
3A, where A, more time than the time specified in subsection 1 is required for an identification parade to be held in relation to a defendant, the defendant shall, instead of the time specified in subsection 1, be brought before the judge within 120 hours after the arrest or detention.
I think the issue is where more time is required for a parade to be held. It's just a matter of speaking.
Sorry, what's the issue?
Nadine, I see your body language is telling me that you have some concerns.
Oh dear.
May
Please
I ask
don't
you
look,
to...
Please don't look at my body language. But no, I...
Well, we communicate with our body language, you know, non-verbally.
Okay, there's some it was a spontaneous response. It's just that I'm trying to understand the need for an A and a B, because what we are restoring is the proviso. The proviso to 1A. It's only saying, all it's providing for is the detention of this individual beyond 48 hours. And it is saying...
Just ask, currently, what time is allowed for the holding of an ID parade?
None is specified.
But isn't that one of the concerns that we were addressing in this reform?
Yes.
That, hold on, isn't it, let us just go back to policy now. One of the concerns we were addressing is that in some cases, no time has been specified for action to be taken. And the risk of that is that suspects languish in custody. And so the policy decision was taken to provide for a longer time to enable the administrative steps to be taken to hold the parade. But we will have, and that's why time bound. So first of all, the reform is responding positively to the concerns raised about the absence of any time frame within which to hold an ID parade, and the abuse that exists in some parts of the system where people languish in custody for long. And so in response to that concern, we are specifying a time frame that we consider reasonable for the holding of an ID parade. At the same time, we are recognizing that even in diligent cases, you may have the eventuality of a parade not being held. And if the regime is that no one is to be held in custody beyond a certain point without facing the court or have their matter reviewed by the court, how do we deal with a situation where someone is in custody, a parade should have been held, the parade has not been held, the time frame specified by the law has passed, but the court now needs to make an order. As exists, the law requires the person to be brought in person. And what the concern is, even as we seek to address the other concern about the absence of time, is that if the person who should have faced the parade did not face the parade is to be taken before the court in person, there is the risk of exposure. And the interest of justice may be compromised in such a case. So we wouldn't be able to respond to the concern about the absence of timeliness or a specified time if we take away the time and simply retain. And if we specify the time without making a provision for the court to make an order in the absence of that defendant who's to face, we would risk exposure of such a defendant, defeating the interest of justice. So that's really what we're seeking to do.
Agreed.
Right, and I think that is what the CPC was addressing, retention of the time bound and then providing for the eventuality. But I think it needs a little more tweaking.
I heard broad, all right, and let me allow CPC to speak.
Let me hear what the policy is so that I can tweak it appropriately, because I really have not heard apparently what the policy is.
The policy is to specify a reasonable time frame, which we identified as 120 hours for the holding of an ID parade, firstly. The policy recognizes that in some circumstances, even with the best effort, a parade may fall through. And in those circumstances, you would want an order from the court as to how much longer you have to hold the parade and how to deal with the person, without the person being brought in person to court, risking an exposure.
I'm just pointing out that the JCF said that they were requesting an amendment that even for that 120-hour period, that the hearing should be in chambers.
Yes.
Okay.
Yes. Yes. As opposed to open court, but I thought it was two things. Is that there should be no need to bring the defendant in person. Because if you bring the defendant in person, there's the risk of exposing to a witness. And you can face a proper allegation that there was a setup to have someone point out the person to then have them identified on a parade.
Madam Chair, could we have the benefit of B again, just to?
I think the
contemplate
CPC
it
is
some more.
working it out.
Okay, she's working it out.
Because the right thing to do, as she
I think
has
she's
done.
warm, based on
Hold
what I'm
on.
hearing.
No,
She's getting hot.
The right approach is first of all to understand what is the policy intent.
Yes.
And once that is clear, then the drafting can take place
Yes.
to reflect it.
Yes.
So the CPC's question is a deliberate question. It's not just trying to tweak a provision. What are you seeking to achieve, and what is the mischief that you are addressing?
Yes.
Why, you see, drafting is reserved for people who are specially trained. That was an issue that was raised repeatedly in the earlier stage, where many people think that you can just draft away. It's a highly specialized area of legal training.
All right. So the tweaking of B would be to add an extra power for the judge to determine, to allow further time for the holding of the parade, after which the person shall be brought before the judge. So to read it again, 3, where A, more time than the time specified in subsection 1 is required for an identification parade to be held in relation to a defendant, the defendant shall, instead of the time specified in subsection 1, be brought before the judge within 120 hours after the arrest or detention. Or,
I think, Madam CPC, my little concern is how the word string. So the more time is required is the more time to bring the person before the court, because you need to hold a parade. Because what the law is saying is that you have a time frame within which to consider the issue of bail. If having considered bail, the decision is unfavorable, then you have to take the person before the court. So the more time that would be required is a time to take the person before the court because you need to hold a parade.
I thought that's what I had said.
I know, but we as lawyers may think, but I think it can give, it may just require a little bit more words from what I'm hearing.
But I read where more time than the time specified in subsection 1 is required for an identification parade to be held in relation to a defendant. How is that not clear that the more time is required for the holding of an ID
I think the time
parade?
is clear to you and me. So where more time is required to bring the defendant right. It's just the little words, the time that is required to bring the defendant before the court than the time that is specified. Because there's 2 time frames specified in one. The first time frame is a time within which to consider the question of bail. And the second time frame is, having considered the question of bail, is to take the defendant before the court. But that's a general scheme.
In other words, B should be focusing on the extension of time, on the second,
right,
on the 120.
Right. So
another extension.
What practically I see is that the defendant is arrested on reasonable suspicion based on the information they have, because they wouldn't have, they would need some more time to prefer the charge. And needing more time to prefer a charge may arise out of any of many circumstances. And in this case, where the more time that is required to prefer the charges for the holding of an ID parade. So you still, once you take the person in custody, there's a first time frame that you have to consider the question of bail. The second is, having considered the question of bail, depending on what you have determined, you have another time frame within which to take the person before the court, for the court to make an order. So it's not the first time frame. Let's go to 1. Where on reasonable grounds.
The first time frame.
It's the first.
Would deal with the second time frame, which is after that.
That's the
time
clarification.
For the holding. But I haven't been able to read B yet. Can I read the whole
Madam
provision?
CPC, read away.
Where A, more time than the time specified in subsection 1 is required for an identification parade to be held in relation to a defendant, the defendant shall, instead of the time specified in subsection 1, be brought before the judge within 120 hours after the arrest or detention. Or B, where an identification parade is required to be held in relation to a defendant, but has not been held within the time specified in paragraph A, which is the extended 120 hours, the matter shall be referred to the judge, who shall either, 1, specify such further time as shall be allowed for the holding of the identification parade, upon the expiration of which a defendant shall be brought before the judge, or 2, determine the question of bail in the absence of the defendant.
Sense that at that stage it was a determination of the question of bail, but it was a matter of extending the time within which the parade is to be held and to make any other order about how the defendant is to be treated. That's
so we're not to have a provision, because I heard talk about having one just to cover the eventuality where the ID parade is not held. So what would happen in such a case? I think you would need that provision.
On further consideration, I think yes, because in any event, once you take someone in, the question of bail has to be considered. So it doesn't mean that the bail, one would hope that no judge would grant a bail where you're saying that the defendant is to face an ID parade. So I agree that instead of the station consideration, it would be transferred to the judge to make that consideration.
person must be brought before the judge? Or are we saying upon the expiration of that 120 hours, then clause B chips in?
Remember now, if all things were working
Yes.
perfectly, and even not perfectly, but much better than they are now, and the society was a little different. Police having had crimes reported, having gathered information through the various means, intelligence, they would speedily embark on their investigation, identify the suspect, prepare the case file, and be in a place to then go after the suspect. And once they arrest the suspect or detain, they charge. When they arrest, they charge. All right? But we do know that you have a situation where even if the case file is ready, the question of identification may be a live one because the person is described by appearance, etc. It may be by a witness who did not previously know him. Mind you, we're getting along the road where now we can use the forensic things and so on. But in such a case, you would have, what is expected is that after you've placed a defendant, suspect defendant, on an ID parade, if the person is pointed out, you proceed to charge that person for the offense for which they are suspected, thereby formally accusing them of the offense. The reality is that multiple offenses may be committed, allegedly committed, by the same person on different occasions who is at large. And the interest of justice would require that different parades be held if there are different witnesses. So even if you may have the person in, you may have a situation where a single individual may be without charge or with charge after the holding of a single parade, if they are to face other parade. But the scheme of the law is that, first of all, we're saying no one should be held in custody unless sufficient cause is there for holding the person in custody. And the law has given good guidance on what amounts to sufficient cause in this society of Jamaica and the approach that is to be taken. Remember, we're not starting from scratch. We're already familiar with jurisprudence around the grant of bail, both at common law and since 2000 under the Bail Act. So if the scheme of the law is that if the threshold is met for you to be deprived, constitutionally and lawfully deprived of your liberty, meaning that you're detained or arrested on reasonable suspicion of having committed an offense, the question is, how long should you remain detained, and what do you do as you go through the different stages of the criminal proceedings? Different rights are guaranteed along the way, and people are entitled to due process. So it depends on which stage you are in the queue. Some people may be further ahead, some people may be at the start. See, there are gaps. The law doesn't set out in detail everything. What do you do between detention and charge, between charge and trial? It's those gaps that we're filling in.
My lady, Madam Chair, yes. But what I'm getting at, Madam Chair, and I understand perfectly what you're saying. No, 5.3b that we have now introduced,
yes,
it speaks to essentially the policy that we're addressing is where for any particular reason the parade does not get off the ground and that 120 hours have expired. And so 5.3b now chips in where the person, the investigators have to approach a judge to ask for more time for the parade to be held. That is after that 120 hours have expired. That's the scheme of the legislation we are proposing here. So what I'm saying is that let's take a scenario where the 120 hours have expired, the parade fell through it fell through, and the police need more time. Is it that the police is obliged to take it directly before the court? And if they don't, let's say the parade is not held, the man is in custody and it's in abeyance, and the 120 hours have expired, but they take no action to seek the intervention of the judge. Well, we know in certain circumstances, if the person is represented, then obviously defense counsel will rush to the court to say, trigger this legislation, 3AB, 53B. The man has not been brought. The 120 hours have expired. What is happening? So my question is this. I know it's kind of difficult to be introducing, multiple time restrictions and limitations because, we get into, difficulties. But would the police be obliged, or would there be a provision to say, or could we include in B, in 53B, a provision to say, upon the expiration of the 120 hours where the police need more time, the police must forthwith?
The real issue that I understand the concerns to raise, is that if you don't want to expose the person, the requirement at 3 now, which says that the defendant is to be brought before the judge, can be prejudicial, and they're really asking for two things. One, that in the case where the defendant properly is to be brought, he's to be brought in chambers. But secondly, to allow for the defendant to be the court to make an order in the absence of the defendant, so you do not risk a prejudicial exposure of the defendant.
Yeah, and I do understand that, milady. And my position is not that they should be taking the accused to the court. It's just that,
so the policy is not to leave it open-ended. The reform response on this matter is to specify a time frame within which ID parade is to be held. We had consultation with the JCF on this aspect of it, so that is a positive move coming out of this reform, is to set time frame within which things are to be done, right? But what the police have identified is that if we left it like this, we might have another harm done, and they're merely asking that we address that other part of it.
Hence the introduction of 53B.
Yes. Let's hear it again, Madam.
Yes, but let's hear it again.
3, where A, more time than the time specified in subsection 1 is required for an identification parade to be held in relation to a defendant. The defendant shall, instead of the time specified in subsection 1, be brought before the judge within 120 hours after the arrest or detention. Or B, an identification parade is required to be held in relation to a defendant but has not been held within the time specified in paragraph A. The matter shall be referred to the judge, who shall either 1, specify such further time as shall be allowed for the holding of the identification parade, upon the expiration of which the defendant shall be brought before the judge, or 2, determine the question of bail in the absence of the defendant.
I don't think it's just upon the expiration of the time that the defendant be brought. I think that's part of the challenge, is that, so you want two things, is that the court to make any order, including considering the issue of bail, including extending the time within which to hold a parade afterwards. But you really don't want a prejudice if the parade is not held to have the person being exposed.
I'm not understanding where this hasn't achieved that. Is it that you want to revert to the proviso after all and forget about the time? Because I'm not getting how this has not implemented all of what has been said before.
I just want to point out that there's what the law provides for now, it's not tying it to bail. What it says at 22, if you arrest or detain an individual, within 24 hours after you have done that, you must bring them before the court. However, if you need to hold an ID parade, you don't have to bring them before the court. You must go to court, and the court can make the order the court thinks fit in the circumstances. So I'm just a little worried that some of the generality is being lost. It's not tied to bail. The person has been detained. A certain time has elapsed, you have to take them to court.
Right.
The court is not constrained in a way that it must consider bail or it must consider the ID parade. It is left for the court to consider all circumstances put before it and make the order it thinks fit.
Right, but
So
this
that's why I was concerned about the latter part, talking about the ID parade and bail.
well, so this law is dealing with a grant of bail. First of all, the law says that if you are lawfully deprived of your liberty on grounds that you have committed an offense, you have to be treated in a particular way. Currently, our jurisdiction really has a system built out with dealing with a person after the person has been charged, or before they are charged is really more around the habeas corpus application. What we're saying is that there are a number of steps that have to be taken along the way. The law and the Constitution itself does not specify everything in detail as you move from one stage to the next. So the first thing is, once you have lawfully arrested or detained someone, what do you do with them? And we're saying that you must consider the question of bail to the person. And you can consider the question of bail in this stage, even before you charge them. But when you are in that early phases, there are some peculiarities, right? So how do you properly consider the question of bail before charging the person if the person is to face an identification parade? What we're really saying, as currently exists, let them face the parade first, and then you consider the question of bail. If having considered the question of bail out of court, there is a denial, then you are to take the person before the court, for the court to then consider that question independently of the previous consideration. If a person was scheduled to face a parade and the parade is not held, and the time frame that the law is now specified for taking certain steps has elapsed, then you need to get an order of the court as to how do you deal with that defendant in the circumstances, right? We know at least two things may arise: allowing more time for the holding of the parade. That's one. I say many things. The court may make any other order, any other order that is appropriate. Right. Right. And any other order may include the question of bail.
Also be release the person.
And it could also be?
Exactly.
It could also be to release the person. Yes, but once a question of bail is considered, it doesn't mean that automatically it is. Because when the question of bail is considered, constitutionally, when the release is either you release on condition, condition could be the bail with stipulation, or it could be an unconditional release. The court is best placed to determine what the interest of justice require, having heard all of the circumstances. We can only prescribe for the treatment. What would be your policy recommendation then, Ms. Wilkins?
That we keep the language where the court may make such order as it thinks fit, having regard to the circumstances.
Without, of course, taking out
Not
the time
seeking
frame.
to draft it, just saying.
No, without taking out the time frame that we are responding to. Okay.
Well, I don't know what to say to that because that's a different policy from what was enumerated here, which spoke specifically to bail. This previous pre-charge regime in 22 didn't speak specifically to that. It was rather open. So I thought this new scheme was putting more precise provision, making it clear that it included an entitlement to bail. If you go back to the language of such other order, you're leaving it a little ambiguous.
Well, it is true that we're seeking to make more precise provisions, but I think it's a recognition that in a case where the defendant should have faced an ID parade and for good reason did not face the parade, other issues may arise. So I think that's really the recognition of taking it a little beyond just the question of bail, but it's really what the interest of justice would require in those circumstances.
So the policy is for the new B2 to state that instead of requiring the judge to determine the question of bail in the absence of the defendant, we're now saying that the judge should make such order as the judge thinks fit in the circumstances in the absence of the defendant. Yeah. All right.
Yeah. I think that would
Yes.
adequately
I
address
think
it.
so. Continue. Continue. Okay. The Bar Association had more comments on section 5.1. So the following are being proposed about section 5.1a, b, and c. 5.1a should be amended and place a clearer and more definitive duty on the justice of the peace and the police. They must decide the question of bail within the prescribed time, not just consider the question of bail.
Page are you reading from?
Page 10, Bar Association.
Okay.
We also urge that the period...
So again, that they're saying 1A should be
they
amended.
They don't like the word consider. They think it should be that they must decide, not just consider the question. Not quite sure how that would work. The 5.1a, the use of the word considered, they want you to say they must decide the question. So it must be decided by rather than considered by, which is...
But the you're considering...
Of course it is.
It goes on to be to say that after considering the matter
Agreed.
specified in 6A, the deciding official shall either grant bail or refuse. So I would think that...
I don't think we should accept that one either. Totally agree. That's neither here nor there. Not accepted. I take it that let me not make the decision for the committee. I was right.
Madam, Ms. Wilkins, you're saying that we should leave that particular provision as is?
Yes, sir, because in the style of drafting, it doesn't mean that using the word consider doesn't mean that you're saying that they're not going to take a decision. The provisions that follow guide the taking of the decision. But in order to take a decision, you first have to consider. So in my view, I would not recommend accepting this recommendation.
Can we hear from Madam? What is your recommendation?
The mic is. Look at the one behind you.
Right. So
Judith, check the one behind you, if that one works.
Yes, I agree with what the Director of Legal Reform has stated.
right. I'm prepared to go with the experts. With oh, I'm so sorry.
Okay, I move to the other one.
Sorry, may I just ask to hear that, please?
Oh, we would not accept the recommendation for clause 51A to be amended to remove the word consider and substitute decide, must be decided by.
The B speaks about what you do after you consider it, what action has to be taken. Right. Okay.
The second, we also urge that the period for bail to be decided by the police or justice of the peace should return to 24 hours. After an officer arrests a suspect, it should not take the officer more than 1 day for a superintendent to consider whether bail is denied or granted, or whether to release the suspect unconditionally. The time for the police to take the suspect before the court is stated in the bill at 48 hours after the initial consideration. The time for a file to be placed before the court for the court to decide the issue cannot be the same taken by a police officer to consider granting bail to a suspect. The police's consideration of bail should be far faster.
As I say, I made a general comment yesterday, is that our system suffers from lack of timeliness in taking action. But our system also suffers from a recognition of work that must be done to ensure that decisions are taken in a timely way. Again, in the same way that specifying a time frame within which to take action for the holding of ID parade is part of what we're responding to. The question about the 24 hours being impractical in certain circumstances and time, especially when you're talking about moving over a weekend period. The fact that you prescribe an outer limit doesn't mean that you use all of it, but you're just ensuring that you're allocating time to enable things to be done before breach of duty and liability begins to run. That's really.
No, sorry, hold on.
Section 51B should be amended so that there is a presumption in favor of the constitutional right to bail unless, in the opinion of the deciding official, one of those reasons sufficiently outweigh the constitutional right. It is worth noting that Section 6.1 speaks positively to a defendant charged with a criminal offense being entitled to be granted bail, unless there is sufficient cause for holding the defendant in custody. A suspect's right to bail before charge should not be expressed in any lesser manner than a defendant who is subject to a charge. The proposed redraft is, after considering the matters specified in subsection 6A, B, C, D, E, or G, and considering the available conditions in subsection 9, the deciding official shall grant bail to the suspect unless, in their opinion, any of the matters so specified justify the denial of bail, and there are no conditions that could reasonably protect against concerns identified by the deciding official. I believe that that issue was also raised by the Norman Manley Law School, that whereas for the person who has been charged, there's an express statement of entitlement, there it was not present for the person who has not been charged but who has been detained. They said they had that issue as well.
Sorry, I want to go back to the time period issue. There's one matter that has been exercising my mind a bit, which is that when you look at the grant of bail after charge, the requirement is for 48 hours detention, maximum 48 hours before the decision is taken. And in relation to the Part 1 offenses, that's a decision that must be made by a judge. So that the effect of those provisions is that for the person who is suspected of committing an offense, one of the offenses in Part 1, the person has to be brought before a judge within the 48-hour period for the judge to take that decision. Now, the provisions in relation to pre-charge bail are also limited to the Part 1 offenses. But the 48-hour period the period of time now before the person is required to appear before the judge is more than 48 hours. And it is more than 48 hours because the JP or higher ranking officer now has that discretion within the 48 hours, and then another period of time has to elapse before the obligation to be brought before a judge. So that there's a bit of an anomaly there, and yes, and if one adopts as a principle that, the term you used was looking at the stages from suspicion, investigation, and so on, and accepting that the person at the pre-charge stage is in a lesser degree of seriousness, and also having...
No, I didn't accept that at all. That's not what I accept at all, because that is an argument that is being put forward. I say, insofar as the deprivation of liberty is concerned, once the threshold is met, the threshold is met.
Okay.
Right.
Let me rephrase it.
People will be down the line, being taken further down the line.
Right. The reasonableness involved in not bringing a person before the court is higher in relation to somebody who has been charged, in which situation the police are more satisfied that the offense has been committed and a trial can take place, in comparison to the person for whom it's at the stage of suspicion, but the the evidence needed to take it to the next stage of the criminal proceedings is not there as yet. So in that context, it would be anomalous for the pre-charge person to have to await, that would be what, 72 hours before coming before the judicial officer, whereas the person who has been charged goes before the judicial officer within the 48 hours. So I would urge reconsideration of the timing issue in that context.
So my mind kind of thinks through the issues a little differently. And my starting point always is, what does the interest of justice require? Balancing, because the interest of justice require that when serious crimes are alleged to have been committed, they be investigated, and those who commit the offense are held to account. Various rights are guaranteed along the way. From the start, from the outset, even before you are accused or suspected of having committed an offense, you have rights, right? You can lose those rights depending on what happens to you or how you behave. All right? So to my mind, when the police charges someone, it's a proper expectation that the things must run at a faster pace than when they haven't been charged, because you now have the material in front of you to say that the ingredients of the offense are made out, that the person alleged to have committed the offense is this person, and then for proof to take place and the matter to be determined accordingly. So the way I have thought it out is that the charge operates, to use another area of the law, almost like a crystallization. Once you get charged, meaning that the police are not in any doubt. I use a parallel with questioning persons. The judge's rules, where you're doing broad investigation, and the minute you determine, having gathered your information, that this person is a suspect, likely to be charged, the rules change as to what you can ask them, and then you have to caution them about the right against self-incrimination, etc., etc. So greater latitude is given depending on which stage you are at. Now, what I hear from the society, including those who have presented, is a reverse thinking. They see that because the person has not been charged insofar as the right to liberty is concerned, that person is supposed to be treated more favorably. But it is not the charging of the person that engages the right to liberty in this context. It's the reasonable suspicion that the person has committed an offense. After charge, other rights are engaged, like the right to be tried within a reasonable time, the right to counsel, etc., etc., etc. So my thinking through, based on the research and what the guidance I have gotten from the instruments, the case law, etc., I think about it a little differently. The interest of justice will require that the realities of the context be taken in, because the interest of justice is never served if, for example, someone who has committed an offense, in their efforts to get away with it, take steps to ensure that no witnesses are available to come forward. But I thought you were going to raise the point of considering the time frame for those who are charged with offenses not punishable with imprisonment. So, like I say, my thinking on the liberty question, it's not just one right that is engaged, but the liberty question, which then speaks to the right, the bail, being in custody or release. I think of it in another way.
All right. So so I'm thinking about it from the obligations placed on the state, having satisfied that there's a proper basis for detention, right? Which is suspicion, reasonable suspicion of having committed an offense. And so that would apply to the pre-charged person and the person who has been charged. The next step is how long before you bring that person before the court if you haven't previously released that person on either unconditional or on conditions, etc. And so the question that I'm working through in my mind is how does one assess reasonableness in that context? And if it is the case that a person who has been charged with an offense has to come before the judicial officer within 48 hours, I'm asking myself, well, why should the person who has not yet been charged have a lesser entitlement? And I use lesser entitlement to mean appearing before the judicial officer, because the concept is that the prevention, minimization, elimination of arbitrariness in terms of the detention is maximized where a judicial officer has that decision to make.
Your reasoning, but when I look at, I didn't see a disparity between 5.1a, 5.1c in terms of time, and then 6.1b, and the 6.2 is the same 48 hours specified. So the point is not borne out by the provision. I thought you're saying that unless I'm reading it wrongly, I think from my reading, and the policy is that it's the same 48 and 48. You were saying 48 and 72.
No, it's two. Oh, sorry, hold on. Clause.
It's not the same? Well, let's look at it and see.
No,
Tell
so,
me.
so clause.
So it says the entitlement, the not held in custody for more than 48 hours, and shall not be held for longer than 48 hours without the question being considered. Right.
All right. And then 6.3 says, in the case of the defendant who is charged with an offense listed in Part 1 of the second. Oh, sorry, where are we now?
No, we're making a comparison of the time frame in the pre-charge regime and the post-charge regime, the time frame. So we start with the time frame within which a question of bail is to be considered as 48 hours.
Right.
And if there is a negative
5.1c
decision on that.
Right, 5.1c.
Right.
So I'm comparing the period of time between arrest and detention and appearance before the judicial officer. So in relation to the
to that provision.
Right. So in relation to the pre-charged person,
yes.
5.1a, the question has to be
within 48 hours.
To be done within 48 hours
right.
by the JP or the constable.
And then they have to be taken before the court within another 48 hours.
Another 48 hours.
Right, yes. So I see that.
Right.
And
another 48 hours after the end of that initial 48 hours.
Yes.
Right.
Yes.
So that's 96.
Yes.
96. Right.
No, man.
But it's not, because the question of bail under B would have been considered there.
Yes.
So it's not as if an additional 48 hours has expired before the question of bail is being considered. This is a second consideration now, so I don't think the times can be layered on each other like that.
Right.
That was
my understanding as the CPC saying.
No, would there not be a situation where
outer time frames are given. Outer time frames are given.
Yeah,
within a time frame that you do certain things. Like I say, prescribing outer time frames, we really only use them in worst case scenario, hopefully. But the reform is to ensure that decisions are taken in a time bound manner.
Right. It's the maxima that I'm concerned about. Well, my question is along those lines. So if the full 48 hours in a particular case elapses for the JP or the
So
or
let
the
me tell you how it
higher-ranked
works out.
officials.
Say, for example, a Friday is taken in. You have not just the 24 hours of the Friday, let's say at midnight dawn. It takes you Friday, Saturday, and then by Sunday, Monday.
At the end of
You're
that
taken.
48-hour period,
Yes.
what is the next? At the end of that 48-hour
For the
period,
question of bail to be considered
Right.
again, secondly, by the court. So you get a first opportunity for a consideration to be done out of court. So you're not putting any defendant through the trouble of having to wait, except if you're charged with one of the offenses where the bail properly is to be considered by the court. So the scheme is to ensure that the person is taken in custody, question of bail is considered out of court properly in a time-bound way, and if the decision, having considered the bail is denied, then the person is taken before the court in another time-bound way.
right?
So when you
And
look on, say, where a weekend intervene, you don't want liability to be created,
And that time-
that's why the time frame is looked at in that way and kept to a minimum. Because I'm hoping that we move the jurisdiction in practice where time frames are honored. And having regard to the need for proper administrative step, not people making out. You know, the problem that I have with where we have gotten in this jurisdiction is that we treat every omission or infraction as if it's willful and criminal. Biggest example, every dispute with the tax authority is invariably viewed as if it's tax cheating, when genuine issues may arise. So if we are not realistic about what needs to be done properly in our allocation of time, we may find that the people who are to take action are just so overwhelmed and overburdened that they can't do anything in a time-bound way. When you set realistic timelines, that is when you can hold people to account properly. Because if somebody gives me a response and set it out, the harm will still be there, if somebody is not served. But when you are balancing everything, if the timeline allocated is not realistic, we don't think always of worst case scenarios. We don't think, if they say bad case make worse law. So I'm not dismissing the concern you're raising. I'm just inviting you to think it through a little more, because, but let's hear it. Let's hear it a little more.
Okay, so using the weekend example, the person who's been charged.
You take up the person at midnight on Thursday, 11:30, 11:49. 11:59 on a Thursday night. You have 11 up to 11:59 on Friday and 11:59 on Sunday. Friday would be one and Saturday would be the next. And then you have the Sunday and the Monday. So by the Monday you bring the person in. Worst case scenario by the Tuesday. Over the weekend, you're not waiting for another later down in the week or Friday and another week or so to pass.
Okay, so for the person who was charged with a Schedule 1 offense, if bail wasn't granted, that person has to go before the judge on the Monday.
I would
That's where we are.
I would hope that is when the soonest opportunity within the time frame,
Okay.
without liability running, the state being exposed
Right.
to legal liability,
Right.
and then the taxpayers' money have to be spent there instead of helping to provide better resources for the business, for serving the people
Right.
in another way.
But for the pre-charged person who is suspected of committing the same offense but hasn't been charged, the police would have another 48 hours at the end of the
Same
Monday
thing would happen.
to bring that person
Show me
before
where
the
that
court.
is provided for.
What-
Sorry, because maybe that's where I'm
maybe I
missing
need to
it.
reflect some more.
Yes, no, I think you're reading it a little differently. Because I just show me what part of it.
There are two 48-hour periods in the
in
pre-charge.
both sets, in both scenarios.
Oh.
In both. Just point me to...
In the charge scenario, where are the two 48-hour
Yes,
periods?
in 6... Remember, one of the concerns raised is how both provisions are phrased. One is saying it's phrased in the negative, one is saying in positive. But in both, it's the same timeline. It's the same initial and subsequent timeline. But just point me to it. Let's see. Let's just check. Madam CPC, can you weigh in, please?
On the issue of the 2 time periods, it's not really 2 time periods because in each case there would have been a consideration of the issue of bail. So it's not as if the person has gone for 2 48-hour periods without the issue of bail being considered. In the first time period on the bail, there is a consideration and a determination made. So C it's basically a reconsideration of the issue after another period of 48 hours. So the person would not have gone for in excess of 48 hours without the issue of bail having been considered and determined at all.
Right. And I'm asking myself if in the context where the provisions reflect an intention, the constitutional provisions reflect the ideal of judicial determination as soon as possible, notwithstanding the fact that the pre-charged person would have had consideration within a 48-hour period. Why should that person not have had that same consideration by the judge in the 48-hour period when the person who has been charged has that consideration by the judge within the 48-hour period? That's what's exercising my mind.
Point me to the provision. Let's look at the provision. Just point me to the provision that you're interpreting that way. I think that may be a little more helpful.
Well, the ones we've just considered, I mean, and in particular C, 5(1)(c), where bail is not granted to the defendant after consideration is made pursuant to paragraph B.
So I would ask you to draw a distinction between if the preoccupation is on the fact that the person is still in custody, as opposed to the question of bail being considered to the person. I don't know if that is what is...
It's the identity of the person who is considering the bail.
Sorry?
It's the identity of the person who is considering the bail, whether bail should be granted or not, is what I'm trying to resolve in my head.
So the scheme is that, except for the accepted cases of judge alone, the question of bail is considered firstly out of court, what in the parlance is referred to as station bail, right? So that no one has to go to court in an appropriate case to get bail if bail can properly be granted at the station. And then the person is, right? So you have that first consideration. If having considered it, you decide that you're not granting bail out of court, then the person is brought before the court and the court considers it. When that consideration is done, the court may grant the bail or deny the bail. The court may order the person further remanded, or the court, depending on what is presented to the court, may order the person released. May released on condition or unconditionally. So I'm trying to, so if the issue, if you're...
The station bail, the consideration of the station bail can't be done in the context of a person charged with one of the prescribed offenses.
So, let's see.
at 6.
All right, part
6.3.
1. Hold on, let's look at part 1 of the schedule. Part 1 and part 2. It's always helpful to look at what is provided for in the law, since that's what is going to be interpreted. So part 1 is where part 1, offenses in respect of which bail may only be granted by a judge. Part 2 is offense for which application for bail shall not be made after conviction. So there is a little concern. If one is that those offenses, we'll have to do some adjustment to the provision, because the way it is set out here, Madam CPC may have just contemplated after charge and not the pre-charge, because if the policy is that regardless of the offense, different things will arise after the charge. Regardless of the offense, punishable with imprisonment, bail can be considered out of court initially. Raise your concern again, Mr. Foreman. I may have a different appreciation of it. Raise it again. That's why I always say let's look on what is actually provided.
Right, so I'll start with the grant of bail after charge.
Yes. Oh, after charge.
Right.
Not the pre-charge.
Right, so, yeah,
okay.
I'm going to start there.
All right, so that's clause 6.
Right.
All right, a person, a defendant who is charged with an offense that is punishable with imprisonment, A, is entitled to be granted bail unless there is sufficient cause for holding the defendant in custody. Shall not be held in custody for longer than 48 hours without the question of bail being considered.
Right. And then subsection 3.
And then in the case of a defendant who is charged with an offense listed in part 1 of the second schedule, the question of bail may be only considered by the judge. But over in the pre-charge regime, the person who is suspected of committing the offense, the bail can be considered out of court.
Yes.
That's the anomaly you were raising. About the who?
Well, it's more the time period. It's fine if the...
Well,
because in the charge regime, if the person can't be held in custody for longer than 48 hours without bail being considered, but bail can't be considered, bail must be considered by a judge in relation to certain types of offenses. It means that for those offenses, it's the judge who has to be deciding the matter in the 48-hour period.
Mr. Foreman, I get you. Okay. I get you. Let's take the lunch. What he's saying is that because of how it is phrased, you may have the person being in custody for longer in the pre-charge regime than how it is in the post-charge regime. I get you. The CPC says she doesn't get you. Tell you what, maybe it's a convenient time to take the lunch break and we mull over it during the lunch break and we try to elucidate. All right. It's 1:24. Let us say we can come back at 2. Is that all right, everyone? 2 o'clock? You can calculate, Mr. Foreman. Are you saying if we take it shorter now, we can probably get out earlier? Or you want to say 2:15?
Get out earlier is definitely preferred.
I see. I totally understand that conflict. All right, let's aim for the 2 p.m. and if a little more time. But it is my hope that we will at least get through this part of the review and complete it, and then we would wait for the reports and the records and time to make the adjustments. But I really think that we have to press on to try and complete this today.
There's another imperative, the corruption prevention declaration, the deadline for submission to the ministries today. I just realized.
Yes, I am in that same. I'm in that same dilemma too. All right, tell you
before
what.
5.
All right, let's take a short break, and we will take it as far as we can to enable everyone to deal with the other time-bound obligations. All right, so let's take the break now and aim to resume at 2. Okay.
Let us resolve our family disputes peacefully. A family is a circle of love, support, and strength. Violence has no place.
The proceeding was brought to you by the Office of the Prime Minister.
Operation Birthright is a government's program to address the major issue of Jamaicans not having birth certificates. According to a recent Capri report, approximately 200,000 Jamaicans have no legal identification, and this affects their ability to register and collect benefits from the government. Operation Birthright aims to provide identity registration support specifically to needy children and adults without legal identification and physical identification documents. Under the program, some $350,000 has been allocated under the National Identification Systems Project to fund the undocumented registration program. Members of Parliament, churches, and community groups are partnering to identify needy persons who can benefit from this undocumented registration program. Being a part of the program is very easy. In order to be eligible, you or the person wishing to register must 1. Have been born in Jamaica, 2. Be aged 1 year and above, 3. Monthly income of 36,000 Jamaican dollars and below, and 4. Not be currently receiving or have received similar assistance under another similar program. Persons can be recommended by any of the following: the head of the Jamaica Council for Persons with Disabilities, senior official in the Ministry of Local Government certifying an individual as a registered poor, member of Parliament, a justice of the peace, public officer, medical practitioner, minister of religion, police officer, gazetted ranks, parish councillor, dental surgeon, principal, primary, secondary, and tertiary educational institutions, veterinarian, bank manager, official representative of the Salvation Army, official representative of the Missionary of the Poor, the CEO, coordinator of a registered civil society organization, the head of the PATH program in the Ministry of Labor and Social Security if the applicant is on PATH. Eligible persons can visit their Member of Parliament's office or any RGD office island-wide to participate in the program. The RGD will then make contact with these individuals for more information so as to have their birth certificates processed. Once completed and the birth certificate generated, the individual will be contacted by the RGD to pick up the birth certificate. For more information on Operation Birthright or the eligibility criteria under the program, visit nidsfax.com.
It's Thursday, March 30. In the headlines, motorists warned electronic warrants coming soon. JUTC workers upset about wage package. In business news, gas prices up by $3.06. Regionally, British Business Chamber of Commerce launched in Guyana. Internationally, UN agrees on a role for International Court of Justice in climate change. And in sports, history-making victories at the ISA Grace Kennedy Boys and Girls Athletics Championships. This is the news on PBC Jamaica. I'm Simone Absalom Gale. There is unrest at the Jamaica Urban Transit Company, JUTC. Some drivers took industrial action on Wednesday, resulting in crowds at the JUTC's major transportation hubs in the corporate area. The workers are showing discontent with their wage package under the government's public sector compensation review. Some commuters had to find alternative means of transportation to reach their destination. Corporate Communications Manager at JUTC, Cecil Toms, says efforts are being made to settle the issue, but conceded that he would not guarantee when the drivers would resume duties. Motorists are being warned that they could be pulled over by the police and immediately brought before the traffic court to settle outstanding matters. This will happen with the introduction of electronic warrants. Justice Minister Delwar Chuck gave the warning Tuesday as he piloted the Electronic Transaction Amendment Act 2023, which was debated and passed in the House of Representatives.
The sheer volume of the documents required creates an unwieldy and untenable situation in the island's parish courts, as the demand for the timely execution of the process outstrips the available human resource capacity. Madam Speaker, we have a situation, where every week, 3,000 approximately, warrants need to be issued across the parish courts. In Kingston and St. Andrew alone, in excess of 1,500. Just consider the paper-based issuing of a warrant. They have to be written up for each ticket, signed by the judge before it is available for execution. And that is why, Madam Speaker, not many warrants have been issued.
Parents are being encouraged to do their part in supporting the children's journey in the world of mathematics. It's a subject that is often associated with anxiety and negative connotations. The Ministry of Education and Youth is celebrating National Mathematics Week between March 26 to March 31 under the theme, Reigniting the Maths Flame, Light Up Your World. A virtual parent forum was held to discuss issues and present solutions on how parents can help to dispel students' negative attitude towards the subject.
Regional Math Coordinator in the Ministry of Education and Youth, Lamar Edgehill, sought to reignite the math flame during Wednesday's National Mathematics Parent Forum. He encouraged parents to play games like dominoes and dice with their children to generate their interest in math.
So what we want to do with our children then is to actually see how we can pull on various resources at home to bring that into the fore to use to bring across mathematics concepts.
Parents are also being encouraged to reinforce the use of mathematics in everyday life.
When you wake up in the morning, you check the time. I'm sure you have to determine how much time you have left before you get out of the house to get to work. I'm sure when you go to purchase an item, you want to ensure that you calculate the correct change so that you're not robbed or you don't rob the person who you're doing business with.
He also listed baking and cooking, sorting and organizing, budgeting and finances as other ways to reinforce the use of math in everyday life.
When we think about the reinforcement, we want to also think about the encouragement factor. Because one of the things that we can't ignore when it comes down to mathematics is the fact that, again, our children may make mistakes. There are times when they'll feel as if they're not learning, they're not understanding, or because they make an error, for them, they believe that, boy, I'm just not good at math. But that's not the case. As parents, we need to ensure that we play our role in encouraging our children so that they can really begin to improve and take on the skill set.
Mr. Edgehill says parents can actually invite their children to teach them the math concepts being taught in school.
So we want to actually ask questions. We want to really query about the homework process. So when your child comes home, you should be asking the question, what did you get for homework today? Let me see it. Invite your child to actually teach you. Because there are times when you may not even understand what it is that is there, but there's no harm in learning a thing or two from your child or your children. So invite them to teach you. And at the same time too, while they're going through the process, encourage them. Show them, help them, make the mistakes with them, and let them know that, look, we're in this together, and over time, if we get at it, we can actually understand the concepts.
According to documents reflecting the nation's goal in educating the masses, it is evident that mathematics has a vital role in the process of development and is considered to be one of the basics of education. The process of education must provide for opportunities to develop and extend mathematical competencies through the use of effective problem-solving processes. For the news on PBCJ, I am Carla Thomas Hewitt.
In the upcoming business report, gas prices are up and over $1 billion invested in Guyana's agriculture sector. Danita Rodney tells us more.
Motorists will pay more for gas when they go to the pumps on Thursday, as state-owned oil refinery Petrojam says up by $3.06. E1087 and E1090 will sell for $167.82 and $172.29 respectively. Up by 25 cents, automotive diesel oil will sell for $191.87 per liter. Ultra-low sulfur will sell for $202.71 per liter, and kerosene will sell for $202.92 per liter. In the meantime, propane cooking gas will go up by $1.19 to sell for $65.64, while butane will move up by 84 cents to sell for $71.76 per liter. Remember, retailers will add their markups to the announced prices. The Bank of Jamaica has kept the monetary policy interest rate at 7%. The central bank announced on Wednesday that the decision to hold the rate was to maintain tight Jamaican dollar liquidity. The next interest rate decision is due in May. As at February, inflation stood at 7.8%. Now for your market updates. In foreign exchange trading for Wednesday, March 29, the US dollar sold for an average of $151.88. The Canadian dollar ended trading at $114.14. The pound sterling traded for $187.55, and the euro sold for an average of $166.66. In JSE trading, the JSE index advanced by 976 points. The junior market index declined by 15 points. The combined market index advanced by 760 points, and the All Jamaican Composite Index advanced by 3,756 points. Overall market activity resulted from trading in 124 stocks, of which 45 advanced, 42 declined, and 37 traded firm. Stocks advanced for 138 Student Living Jamaica Limited, AMG Packaging and Paper Company Limited, and Blue Power Group Limited. Stocks declined for 138 Student Living Jamaica Limited Verbal Preference, Barita Investments Limited, and Berger Paints Jamaica Limited. Trading firm were Derrimon Trading Company Limited, Epley 7.50% preference shares due 2024, and Epley Caribbean Property Fund Limited SCC. The overall volume leaders were Key Insurance Company Limited with over 44 million units, Trans-Jamaican Highway Limited with over 7 million units, and the Fosrich Company Limited with over 2 million units. In regional stocks, in Trinidad and Tobago, Calypso Macro Index Fund posted a volume of 357 shares. On the Barbados Stock Exchange, Goddard Enterprises Limited was the sole security trading 20,000 shares. In regional business, in Guyana, 24 contracts amounting to over $1.1 billion were signed on Wednesday by contractors for works to be carried out in the coming months for agencies across the agriculture sector. More in this report.
Contracts over $1 billion were signed by the Agriculture Ministry on Wednesday to further advance the sector as part of its vision of achieving food security. To further overhaul the sugar industry, $532 million in contracts were inked for the Ghana Sugar Corporation, Gaisuku.
This year, we are hoping that the Rose Hall estate will be operable in the second crop, and there are a number of projects that are earmarked both for Albion, Rose Hall, and also the other two estates, Blairmont and Iflot.
For the Mahikoni Aberi Agricultural Development Authority, MMA-ADA, a $26.9 million contract was inked for the upgrading of the primary access all-weather road along the main canal after it was deteriorated due to inclement weather. This will benefit 40,000 acres of livestock, rice and other croplands, and 1,200 farmers.
So I want to urge you that let us work together. Let us ensure that the project commences on time. Let us do it to the standard that is in the contract. Let us ensure that we abide with all the rules. Let us also ensure that we do it in the stipulated time that is provided in the contract document so that everyone will be satisfied. And you know for a fact that the people out there, they are expecting a service from the Ministry of Agriculture and the government of Guyana, and we have to deliver that service through you.
For the National Drainage and Irrigation Authority, a revetment will be constructed at Flagstaff, Cane Grove, and a concrete bridge will be built at number 10 Perth Baibu Channel. In addition, the access road at Undernaming Phase 2 will be rehabilitated, while 16 pontoons, 10 pumps, and 10 excavators will be rehabilitated in regions 2 to 10. Some $15 million was inked to further advance the fisheries industry.
In international business, Wall Street gains with rosy outlooks from Micron Technology and other companies ease some worries about the economy.
U.S. stocks ended sharply higher on Wednesday, as upbeat outlooks from Micron Technology and other companies helped ease worries about the economy. The Dow climbed 1%, the S&P 500 added 1.4%, and the tech-heavy NASDAQ Composite jumped about 1.8%. Memory chip maker Micron Technology's shares advanced 7% after it gave a rosy outlook for 2025, indicating artificial intelligence would boost sales. Adding to the optimism, Lululemon Athletica jumped after an upbeat annual results forecast.
Today, it looks like people are just kind of breathing a sigh of relief.
Scott Ladner is Chief Investment Officer at Horizon Investment.
Frankly, we have interest rate volatility that's coming down, and that's leading to equity volatility that's coming down. It's leading to risk managers being able to put more money at work. And we are having a little bit of I guess some fears about more banks failing are starting to subside, and that is leading to people just basically willing to put money back into this market.
The S&P 500 Banks Index rose 1.4% to close at its highest level in over a week, the latest hint of calm among bank stocks after regional U.S. lender First Citizens Bank shares scooped up the assets of failed peer Silicon Valley Bank earlier in the week.
In market data for oil prices rose as a surprise drop in U.S. crude stockpiles and a halt in exports offset a smaller than expected cut to Russian supplies. Brent crude futures rose 49 cents to $78.77 a barrel, while West Texas Intermediate crude rose 58 cents to $73.55 a barrel. And that was the business report on PBCJ. I'm Danita Rodney.
In regional news, Guyana and the United Kingdom on Tuesday celebrated a triple treat with the official launch of the British Business Chamber of Commerce Guyana, BritCham, which follows the removal of the visa requirement for Guyanese traveling to the UK and the return of British Airways to Guyana-UK route.
Prime Minister Mark Phillips and the high-ranking government delegation joined British High Commissioner Jane Miller and visiting UK Minister David Rutley at the High Commissioner's residence Tuesday night for a reception in honour of the launch of the British Chamber of Commerce Guyana BritCham. The move to establish the new business chamber comes on the heels of the announcement of visa-free travel to the United Kingdom, a direct British Airways flight, and the signing of a partnership agreement by Guyana's Minister of Foreign Affairs and International Cooperation UTAD and His Excellency Trade Commissioner for Latin America and the Caribbean Jonathan Knott in November 2022. PM Phillips said while the chamber offers an advantage to expand trade and tourism, Guyana also wants support for its ambitions of becoming a regional hub for food and energy security and environmental services. He particularly referenced the partnership agreement signed last November between Guyana and the UK and said he would like to see action to implement the pact intended to deliver innovation, technology and knowledge for greener growth in Guyana.
We would like to see increased cooperation between Guyana and Great Britain in these areas, and it is our wish that your visit, Minister, here will lead to a qualitative shift in our economic relations. With all the signs of advancement, there can be no doubt that Guyana is poised for greater success in the future.
The formal creation of BritCham Guyana was announced back in February on the sidelines of the 2023 International Energy Conference and Expo at the Marriott Hotel, Georgetown. British and Guyanese companies are encouraged to contact BritCham Guyana to sign up as members to enjoy the full benefits of its support in exploring and accessing each market. High Commissioner Miller said she's convinced that even with other well-established and competing business representative bodies, there is space for BritCham Guyana to succeed, a sentiment supported by the United Kingdom Parliamentary Under Secretary of State David Rutley. The new organisation will be chaired by Gyson's Group Chief Executive Officer and UK Guyanese citizen Faisal Khan, supported by a board of leading business executives with close ties to both countries, with an office at Pegasus Suites and Corporate Centre in Georgetown.
It's a clear win-win. It's a clear win-win. It's a win for Guyana and it's a win for the diaspora. That's exactly what we see BritCham being. A win for Guyana and a win for Great Britain.
Over the weekend, Prime Minister Mia Moore-Motley, in her address at a fundraiser held by the Barbados Canada Foundation, expressed alarm at the ease in which people in the U.S. are able to get automatic weapons. Prime Minister Motley says the region continues to suffer from the trafficking of illegal firearms, as she called out countries who refuse to curtail the sale of automatic weapons in spite of the clear evidence of the impact.
And regrettably, you in Canada and we in the Caribbean continue to suffer as a result of that movement and trafficking of arms, and causing our societies now to be literally torn in ways that we have not prepared ourselves for. A fella might have hit a fella with a 2x3 before. A fella may even have let go a single shot. But when you start to use automatic weapons that spray bullets, notice the verb, spray, then we have a problem for the stability of our societies. Because it means that the person who is least mentally capable will determine the well-being and welfare of a family, a community, and a country. The mission that we want to set ourselves and the conversation that we are having in our social partnership with the private sector, with the labor movement, and we are about to broaden it in the next month, such that by the 1st of May, we want to settle a mission that will allow us to achieve that world-class status. We want to be blue and green. Aye. You can either choose to look at Barbados as a small island developing state, or you can choose to look at us as a large ocean state. A large ocean state at a time when the next frontier to save this planet is the ocean.
In Antigua and Barbuda, several local first responders have received training in dealing with emergencies related to electric vehicles. It comes as part of the Department of Environment project to increase the number of EVs in the country. Jamie J. Rocher reports.
First responders are getting a lesson on the general workings of electric vehicles. They're learning how emergencies with EVs differ from those of gas and diesel-powered vehicles. The training falls under a component of the Environment Department's Sustainable Low-Emission Island Mobility, or SLIM project. Project coordinator Melissa LeBlanc says they're working to increase the country's uptake of electric vehicles.
And it's also to support the implementation of Antigua and Barbuda's nationally determined contributions. So Antigua has committed conditionally, based on finance that you would get internationally, to transition to 100% electric vehicles in the government sector by 2035, with an overall transition in Antigua and Barbuda by between 2040 and 2045.
Stanley Barreto is the director of Megapower Antigua, which sells and services electric vehicles in this country. As a lead training instructor, he explains the best ways to identify electric vehicles during emergencies and how to approach an EV fire incident.
It is generally recommended in the event of a high voltage battery becomes involved in fire, allow the battery to burn itself out. Unless you wish to use an Olympic pool-sized amount of water or you have the appropriate extinguisher, it's not going to stop.
But he says these types of fires are rare and will eventually cease to occur since manufacturers are modifying the chemistry of the batteries. Firefighters and emergency medical technicians were among the participants. The training was also open to personnel from the Defense Force, Transport Board and ABSA, as well as taxi drivers, insurance companies and electronics technicians. Jamie J. Roche, ABS News.
In international news, the United Nations General Assembly has adopted a resolution proposed by the South Pacific island nation of Vanuatu to seek an opinion from the International Court of Justice on what legal obligations nations are under to protect climate systems and people affected by climate change.
A historic decision that campaigners say is a major step forward for climate justice.
It is so decided.
No vote was needed, the General Assembly deciding by consensus to ask the world's highest court, the International Court of Justice, to determine what obligations countries have for the climate damage they've caused.
Festering climate injustice feeds divisions and threatens to paralyze global climate action. So, Excellencies, for those on the front lines already paying the price for global heating they did nothing to cause, climate justice is both a vital recognition and a tool. Recognition that all people on our planet are of equal worth, and a tool to build resilience against spiraling climate impacts.
The efforts to negotiate this treaty were led by the Pacific island of Vanuatu.
This was the end of a very long campaign. How did you feel in that moment?
I'm a very, very happy person because I can assure my kids and the kids around the world that the leaders of the countries of this global community are actually listening to the plight of the future of mankind.
The small island of Vanuatu suffered a devastating cyclone earlier this year, highlighting the fact it's a country that's whole existence is threatened by climate change. The original idea for the UN resolution actually came from law students studying here at the University of the South Pacific. One of them was Cynthia Hauniuhi.
It's surreal. I still can't believe that we've gotten this far, and it's a testament to a lot of the determination that youths have. It's a testament to when youths are moved by genuine concern, not only for their future, but the future of our generations yet to come.
At the end of the meeting, the UN Secretary General told me it was a big victory. But UN insiders say, even though this resolution passed by consensus, there are some major countries which have a problem with it. And they expect some national submissions to the International Court of Justice in an effort to narrow the eventual ruling of the judges. James Bays, Al Jazeera at the United Nations.
Despite living in Africa's most industrialized economy, nearly a third of South Africa's workforce is jobless. While President Cyril Ramaphosa says youth unemployment is a national crisis, some people say his aging government is not invested in their future.
Tokondo Nkose's mother hasn't worked for years. He's also unemployed and has a family to look after. At 29 years old, he says young people like him are growing increasingly despondent about the lack of job opportunities in South Africa.
We are getting irate if we aren't already. We are getting frustrated with what is happening and what we are seeing. we are really getting, or we are already up to here with the promises that have never been met, not even one.
His mother is worried.
I wish that government would actually take this very serious, because it's driving our youth to depression that is leading to drug addiction.
Nearly 3 decades after the end of white minority rule in South Africa, most of those feeling marginalized and economically excluded are poor and black. Critics blame the high unemployment rate on a number of factors: global events, the pandemic, and corruption.
South Africa has one of the most unequal societies in the world, and the gap between the rich and poor is growing. Millions are trapped in poverty. High levels of unemployment here don't make things easier.
In sports, history was made on the second day of the 2023 ISA Grace Kennedy Boys and Girls Athletics Championships inside the National Stadium in St. Andrew on Wednesday night. Kingston College's star sprinter Buaji Nkrumah ran a sub-10 in the Class 1 boys 100 meters. The speed doctor stormed to victory in a record-breaking 9.99 seconds. Nkrumah becomes the first schoolboy in Jamaican track and field history and the third junior athlete worldwide to complete the blue ribbon event in under 10 seconds. In the girls' side, Heidel's Alana Reid delivered a scintillating sub-11 seconds in the girls' Class 100-meter clash. She stopped the clock in a new national under-20 record of 10.92 seconds. That time is below the previous national record of 10.95 seconds set by Tina Clayton last year. It also broke Veronica Campbell-Brown's 22-year-old championship mark of 11.13 seconds set back in 2001. Boys and girls champs continues until Saturday, April 1. Republic Bank Limited, the largest indigenous bank in the English-speaking Caribbean, has been announced as the new title sponsor and official bank of the Caribbean Premier League, CPL.
The second most viewed T20 tournament in the world made a huge announcement today at the Queen's Park Oval in St. Clair, and TTT Sport was there.
With the anticipation of the Caribbean Premier League set to begin this year in August comes big news. Republic Bank is now the title sponsor for the period 2023 to 2025.
CPL's Chief Executive Officer Pete Russell made the revelation of the partnership, which will span over a 3-year period.
And it's with great pleasure and great excitement and anticipation that I am able to announce today that Republic Bank will become CPL's new title sponsor for the next 3 years.
Meanwhile, President and Managing Director of Republic Bank Limited, Nigel Batiste, said the bank chose to expand its long-standing relationship with the CPL while celebrating over 185 years as a banking institution.
I mean, we are very eager. We look forward to working with you. Our teams look forward to working with your teams. We think that the Republic Bank Caribbean Premier League could be an experience like no other. And our intention is that working together with you guys, right, that we will show the world who the Caribbean people really are.
Republic Bank has also been confirmed as a partner for the Women's Caribbean Premier League, which will return in 2023 for its second edition, with another revelation made by the CPL CEO.
The women will play in Barbados and Trinidad this year. So, yes, we can officially announce that the finals of the women will be played in Trinidad.
The tournament's player draft is set for June 5th, with the 2023 Republic Bank Caribbean Premier League bowling off on August 16th to September 24th, 2023.
And that's the news on PBCJ. I'm Simone Absalom Gale. You can follow us on our social media platforms at PBCJamaica. Thank you so much for watching.
Twists, turns, ins and outs. From the four corners of the earth, PBCJ presents Globe-Trotting Yardie with Carol Francis.
There are numerous ways of traveling across the city of Delhi.
Tantalizing, breathtaking and revealing, bringing you the wonders of travel from across the world. That's Globetrotting Yardy, right here on PBCJ, the People's Station.
I know one day monkey want wife. I better say it in a nice Jamaica way, you know, because they wouldn't say nothing like want. I know one day monkey want wife. In other words, you don't know how often you'll need help in the future. So you be careful not to turn your back on those who help you. I know one day monkey want wife.
When it comes to mealtime, children can be very picky. But nutritionist Nicole France shares one solution that may help.
As soon as children can put solid food into their mouths, introduce them to fruits, vegetables, peas and beans, so that they get accustomed to the taste. These are all healthier choices for children to eat. And then we need to be aware of what's in the food that we're giving the children. So reading food labels, read the packages, look to see how much sugar is in the food, look to see how much sodium is in the food, how much fat is in the food. See if there are any nutrients and anything healthy that the children will get from what you are giving them. So read the food labels.
India's development cooperation is a key component of India's foreign policy. It is free from conditionalities and is strongly rooted in the principles of partnership, mutual benefit, and solidarity. India believes that growth and prosperity of the world are indivisible. We all grow together.
ITEC is demand-driven. Whether it is agriculture, rural development, governance, banking, or environmental sustainability and climate change. Besides sharing our ancient knowledge in Ayurveda and yoga, ITEC also shares India's globally acknowledged expertise.
Friends, it gives me great pleasure to convey good wishes on this important ITEC Day, which is 15th September, that we celebrate every year, involving ITEC alumni around the world, our Indian missions, and foreign governments. The ITEC has come to be universally recognized as a symbol of South-South cooperation. It is a reliable brand in capacity building, under which more than 200,000 professionals have benefited through various ITEC programs in the last 57 years. Today we offer around 14,000 scholarships annually for 160 partner countries through more than 100 premier Indian institutions, including Indian Institute of Technology, Indian Institute of Management, and various defense colleges. Even during the pandemic, we have reached out to our partner countries through e-ITEC program. Our endeavor is to expand the capacity building initiatives of our partner countries in their development activities. India's relations with partner countries are based on our ancient philosophy of Vasudhaiva Kutumbakam, the whole world is one family, and the ITEC program truly embodies that spirit.
Namaste, I am Meera Prajapati, working as a scientist in Nepal Agricultural Research Council in National Animal Health Research Center since 2012. Not only the training course, we were also treated very nicely there, and we also got the opportunity to interact with international participants. I still remember the moment.
The break, just to say in respect of Clause 5 and the issues raised, I think the comparison between Clause 5 and Clause 6 and the reference to offence listed in Part 1 and 2, there would have to be a little tweaking of the heading of the second schedule under Part 1, tweaking of the offences with respect of which bail may only be granted by the judge, because there is a different consideration where the defendant is not yet charged. So, Madam CPC, I had discussed this with you during the break, and I think you've agreed. May I hear from you? Not necessarily what you will consider it to be tweaked at, but...
Yes, I had agreed, because the heading is a little wide when, in fact, the limitation about consideration by a judge only applies in respect of the charge regime and not the pre-charge regime.
All right, so we are here at our deliberation on Clause 5, and we are well on our way through it, because we had considered other matters along the way. But I was thinking about the totality of the submissions raised over the many meetings of the committee. Many would not have appreciated my early boldness and confidence in the constitutionality of the regime. It would have been highly irresponsible to have come to the House with a regime that couldn't withstand scrutiny. And this is not to say that legislation passed cannot be held to be inconsistent with the Constitution. I'm making the point that the issue was considered at length and after much research. I have noted the useful comments that have come in about making the bill more readable, more understandable, and better presented to achieve the policy goals. And I think that it may be helpful in light of submissions and recommendations, and even questions about the comparative status of a defendant before charge, after charge, and to see if there may be a better way of providing for the treatment of their liberty. I had a discussion with the technical team during the break and wondered aloud with them whether it may be useful to provide generally for the treatment of the defendant who has been arrested or detained on reasonable suspicion of having committed an offense, and set a general standard of treatment, and then go on to provide, there's a rearranging of the bill for what happens where more time is required to bring the charge, whether because an ID parade needs to be held or you need to put together the evidence so that you're not having a matter stuck in the court prematurely. And then what would happen after the person is charged and awaiting trial. So I was having that conversation. It would just mean that we would have to rearrange the bill, and perhaps we may have to give the CPC some time to redraft it. Madam CPC, may I invite a comment from you? You know, I don't, as your minister, I don't want to increase your workload.
Well, Madam Chair, I would only hope that it is clear that the redrafting is based on the change in approach now. Because
I'm sorry?
That the redrafting is based on the change in approach which we discussed just now.
Yes.
Otherwise, it sounds a little...
No,
I don't know whether to take it to heart.
No. Just to say, what do you understand, just in respect of, based on the discussion? I just wanted to be clear.
Well, we had discussed ways in which we could streamline the treatment of the pre-charge and the charge regime, so that we minimize the possibility of any provisions that don't sink and any inequalities. So in order to do that, it suggested that we do a little redraft.
Yes. May I invite a comment from the chambers and then from the Legal Reform Department? Since we were all in the conversation during the break.
No objection from my side.
Similarly, we're at item on the placement of the provision, the entitlement to bail, and I think it also answered several of the concerns on constitutionality that the persons who submitted submissions had made. There's just one thing.
Not that it answers it, it better addresses it.
Addresses, yes, indeed. In some cases it answers too, but yes. Just to be clear though, I'm not sure if at the break where a decision was taken concerning the reference to Part 1 or Part 2 of the second schedule in 5.1, in the second line, is the outcome of the discussion that everything in 5 would relate regardless of the offense, and so there is no need to put an offense listed in Part 1 or Part 2 of the second schedule? I'm trying to remember. Was that where we came out? Well, the reference to Part 2, I think, is an error, and I think the CPC had already...
I see the chambers wants to weigh in.
Sorry, my understanding of the policy intent was that the pre-charge regime would be limited to certain types of offenses.
Yes.
And that those offenses would be, the ones listed in Part 1, in Schedule 1.
So then we're removing the stipulation that it can only be heard by a judge.
In respect of the pre-charge. That's the reference to the tweaking of the heading. So the heading, as is now, is really referring to those who have been charged.
It never applied to the pre-charge. It's because what was there in relation to consideration only by a judge specifically said where the person had been charged. The
reference is just to the type of offenses.
Right.
But it still needs some clarity around it. What we're saying is that if you are suspected of having committed an offense of the offenses listed there, then you're treated one way. And if you are charged with committing one of those offenses, then the bail would be considered only by the judge. No, it's not an out-of-court situation, but it does have to be tidied up for clarity.
Because then 51A would be thrown
into... It has to be
into...
tidied up. It has to be tidied up for clarity.
Okay.
Right. So, members of the committee, the conversation is not meant to exclude members with the technical team, but you appreciate that we rely on the technical team. I think it's just that I've always believed that when we open up a process to hearing from the public, it doesn't matter how different our views are, then the process will cause an improvement in the outcome. And when we take into account, certainly as chairman and minister with carriage for the bill, I think that some of the concerns around how the bill is structured, how the provisions are made are valid concerns. And we can streamline. Not that anything is wrong per se, but can be made better. It's not easy work to draft law, even though some people may think. It's a highly technical work to ensure that there is internal coherence, referencing are correct, that if you're not running afoul of principles of law provided for in other pieces of legislation at common law, etc.
Madam Chair, just to say that from me personally, you could continue speaking to them for another half an hour, because what you're talking about are things that I have raised and near and dear to my heart. So I have no problem with you all speaking to each other. Half an hour more? If you just sort it out, because this would mean that we're getting there. We're getting there.
Not only that, it means that we really are improving on what we have done. So I have said before, and I will say again, that when I open a process for consultation, collaboration, review, it's a genuine process. It's not just an empty going through for optics. It's genuinely to hear from people and to take and to properly consider their input and to ensure, as far as possible, that where appropriate, the product reflects the input. On that note, I think we could then take the adjournment, because we would have made substantial progress and the finish line is in view. The time would also enable the clerk to prepare the outstanding record. And I think with the other matters scheduled, probably a 2-week or so break, minimum of a 2-week break would be appropriate for us to come back with the revised draft and to allow time for the outstanding minutes and beginning of the report or a draft report to be ready for consideration by the committee and then to the House. So say all of us? So say all of us, including the supporting team?
Aye.
All right. Then those who have other business that will not impact on other business may skip off and enjoy. I remind everyone, and speaking to myself, we have the statutory declarations to submit, and please ensure that we are all compliant, all right, as lawmakers and the persons in the law guiding the government. All right? Unless anyone has anything else to add, will someone move for the adjournment? That was quick. Senator Campbell Rodriguez. Seconded by? Seconded by Member Williams. So, no, I have to take that back. Date and time of the next meeting. Madam Clerk, 2 weeks from now. Let me Thursday the 13th. Thursday the 13th of April. Let's ask for 10. We can put it for 2 and then I'll ask. Mr. Brown. He has 10. It's confirmed. All right. Put it 2 then. 2. All right. So we will meet on Thursday, the Thursday the 13th at 2 p.m. But let's look for a date in the following week. What about Thursday the 20th also? Yes. And right. So April 13 and April 20 at 2 p.m. All right. So the next 2 sittings of the committee will be on April 13. Sorry? All right. Yes. So the 13th and the 20th, 2 p.m. Very well. We can now take the adjournment. May I wish for everyone a pleasant weekend. Remember, you still have a working day before the weekend starts. You still have tomorrow, Friday, working day. Right? So when I say a pleasant weekend, it's after the next working day, after the rest of today's working day, and the next one.